Honor.
Your Honor, read TA.
We could take up one new matter just so that we're making some progress. And it's a matter I submitted to Solicitor Gibson and to your clerk a moment ago. I don't know that you even had a moment to look at it, but I have. Go ahead. Well, Your Honor, we live in kind of a new time, the era of Murdoch. And when I began practicing law in the 70s and the 80s and the 90s, we used a time-honored device in high-profile cases, sequestration of the jury. Now, we did not move for sequestration, nor did you choose to do that, Your Honor, and we respect that decision. But at this juncture, Your Honor, this case has garnered so much publicity, so much, I think I can't understate the polarization in this community about this case, and that's for a variety of reasons, but I've submitted to you and would ask to make as a court exhibit several pieces of paper. One is simply a photograph that was posted on Instagram, I believe, and it is one of the more tame, I'm told, though I'm not, I don't cruise the internet, certainly not during a trial, but I am told that there are TikTok messages that if there's not a conviction in this case, that the courthouse will burn. I know that that's of concern to everyone. There are, yesterday, the third piece of paper, which is a dark text message, was received by a member of my client's family, and they sent it to me immediately and made no response to it. But it's alarming because it represents the other polar, what I would call the skinhead white supremacist, that lunatic fringe. And Your Honor, in the middle, as we have said, the narrative in this case, beginning shortly after the incident, it hasn't been helped by the statements of public officials. I've attached that, but it's already a part of your record elsewhere. And then I've highlighted a portion of a news article, which I won't read because I've highlighted it for you, but it suggests that somehow this trial, instead of being a fact-finding mission resulting in a neutral, detached jury's deliberation and determination of guilt or innocence, is somehow a moratorium, and that justice will fail if the event that this journalist seemed to suggest is the result that should be obtained. But, Your Honor, for all of those reasons, we rely on judges' instructions. We hope, we keep our fingers crossed that juries will take that to heart, that they will avoid interference, that they will report it to the court. But we know from the Murdoch case, that just doesn't happen. Now, that case is different because it involved the interference of a court official, one who, as our Supreme Court said in that opinion, was the court's representative. So the jurors could have easily felt, as they did in that case, that it was okay because that was the court's caretaker. But I think that there is the very real potential, given the amount of publicity attendant to this thing, Your Honor, that I would ask the court, though it is inconvenient, it will take 10 minutes, and I would not oppose you, Your Honor, going to the jury room and pulling them one at a time out in the hall. I don't know that we even need to be present. I don't know that the prosecution will have a position on this, but I do think it's important not to poll them as a group. I think it merits, in order to assure a fair trial, that is free from any taint, interference, suggestion, even to the extent of driving by the state capitol this week, you're likely to have seen a poster. And I don't want jurors to think that they're getting themselves in trouble if they have seen something that may have caused them to think in an inappropriate way. But I do ask, Your Honor, with all respect for the time, the economy of time, but I think it is that important. Thank you.
Take position.
Your Honor, I don't think we need to bring any additional attention to this matter, Judge. I mean, the things that Mr. McCullough has brought out, I appreciate the fact that he brought it to our attention, but we can't control what the outside world does. And I mean, posts by people who were not involved in this case, that we had admonitions that were given, And to our knowledge, and what we know is the family's done everything they're supposed to do. They've not posted, they've not engaged, they've not done any of the things that the court has asked them not to do. What the rest of the world does outside of this courtroom is what the rest of the world does. What the rest of the world calls us, calls prosecutors, I really don't care. We're here to do justice, and that's why we're here now. To ask the jury to do something additional now, Judge, if they've got a question, they have the ability to write it down. They got the ability to say, hey, Judge, this did or didn't occur or whatever. And to my knowledge, that's not taking place. So in order to pull them out and start kind of poking and asking, specific questions of them, I just don't think it's proper at this point. We've had other high-profile cases. We've not done it. We didn't do it in the Uber case here. We didn't do it. I mean, it's not been done that I can recollect. I'm not almost 30 years of practice in law. I've not had a case where that's happened, and I don't think that we need to start doing it now. If the jury has a question, they understand your admonitions. These are grown folks who went through the process. They've adhered to everything that you've asked them to do at this point, and there's no need to start pulling them out and searching for something when they're not telling you that anything is going on. I don't think it's proper right now.
Your Honor, I would simply say that as I mentioned, we sequestered juries for many decades. And we did so at a time when the only access that jurors could have to taint themselves were much less than today. There were 3 TV stations. There was no internet. There was no social media. There were neighbors. And those opportunities were the only opportunities to be tainted by public opinion. And yet, for 3 decades or 4, our courts sequestered juries. To the best of my knowledge, we stopped doing that because of the expense. Okay, I get it. But today, 1,000 television channels, social media platforms that allow the worst and most scurrilous, degrading, disgusting conversations, even to the point of threats of violence and threats of destruction, that is so ubiquitous, Your Honor. And I think, I don't know that I recall making a motion like this, but having gone through the crucible of the Murdoch case, I recognize a couple of things. The frailty of a jury's willingness to come forward. And that's a human nature. It's not a dishonesty on the part of the jury. It's just a belief that it doesn't need to be reported. So I would ask again, Your Honor, while it may be novel, but I think it is necessary. And the mere fact that it hasn't been asked before of you or another judge, whether in this courtroom or another, I don't hesitate or have any embarrassment about asking you to do it now to ensure against the possibility that any juror has been contacted or otherwise stumbled in to the receipt of information. Thank you.
All right, well, I don't know your position on that, Mr. Bell. I don't think there's any real procedure for doing that, and I see it as fraught on a number of levels. If I were to go back there and examine each juror individually myself, again, based on what we learned from the court's ruling in Murdoch, I'm hesitant to have any sort of conversation off the record outside the presence of all the lawyers with any juror. So I will deny your motion in that regard. What I am going to say, though, too, is the stuff here that you provided is troubling, although there's been a lot of troubling things all weekend. Lawyers, and I guess I'm more talking to the public here, we just all need to turn the temperature down, much like I cautioned the lawyers Wednesday to turn the temperature down. The public does too. This matter is actually only a matter of life or death with the Combat Belton family and the Chow family. The rest of the folks don't need to be sending messages like this to lawyers. I actually got emails myself over the weekend, which reminds me I need to send a sled. Please, folks, just turn the temperature down. There will be a verdict maybe here today, and we're all going to be respectful of one another. And I want to commend everybody who's been in this courtroom for the week, or all last week. Everyone here has been respectful to one another. There have been no issues, there have been no outbursts, and I commend you all on that for being respectful of your neighbor. But we're going to continue to do that, and that's how today is going to play out. With that being said, what else? Jury charges.
Yes, Your Honor. I think we just have two quick issues to bring up with regard to what the defense's position is with final charges. We did send an email to the court yesterday afternoon with the one edit and the one addition. First of those would be to add within the element about bringing on the difficulty. Our position is that the language and the court's draft, the cleanest way to make this edit would be at the bottom of 16 going into 17, that if the conduct of the person defended or the defendant was unlawful and of the type which was reasonably calculated to and did provoke a deadly assault, and continuing from there. In support of that language, we're relying on State versus Bryant, 336 South Carolina 340. That's from 1999, and that exact language was reiterated in Slater, and that's 373 South Carolina 66. And the direct quote from those cases is that any act of the accused in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty, and would bar his right to assert self-defense if those conjunctive conditions are met. So that would be the first request that we have. And we also do believe that the evidence adduced over the course of this trial does squarely put the issue of withdrawal in front of the jury, and that is a question that they must decide whether. I don't think it's going to be any surprise that the state will argue that Andy Chow and or Rick Chow were at fault in bringing on this difficulty. With respect to the testimony that we have received over the course of last week, Andy's conduct, his act, the jury could find that act amounts to a withdrawal from any potential difficulty the jury may have found he had brought on. And if that withdrawal was effective, then his right to self-defense, and by extension, Mr. Chow's right to defend him would be restored. And in support of that withdrawal charge, the language of which is one's right to self-defense is restored after a withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act. And that or act portion was emphasized, I believe, in State versus McCarty. That's 437 South Carolina 355. And that is also quoting the Bryant case at 336 South Carolina 340. We do believe that the withdrawal law does need to be charged to this jury in light of what's been adduced over the course of last week.
Continue, State.
I just don't recall any testimony regarding any withdrawal. This was one continuous act, Your Honor. I don't remember any testimony whatsoever of withdrawal. It was a chase that went 130 yards, and there was some backing up that was testified to, but it was right at that moment. This was a bam-bam kind of situation where it was.
Okay. Here's what I'm gonna do. I did look at all this. As far as the violation of the law language, I'm not going to charge on that. I think the implication of that charge would mean that there would have to be a violation of the law for someone to be not without fault. So I'm not going to put that in there. I am going to add the language of withdrawal. It is in the final charge. It will be on page 18 at the bottom. And here's the exact language. And it went a little further than what you asked for, Mr. Copeland, because I think you sort of cut it all short. Here's the exact language. One right to self-defense or defense of others is restored after withdrawal from the initial difficulty with the victim, if that withdrawal is communicated to the victim by word or act, Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. So went a little further, then just, I guess you pretty much had the first sentence, but the model charge that we have added, that basically has to be essentially unequivocal, that the person defended is withdrawing. So that's how I'm gonna do it. Y'all have been emailed a copy of the final charge as well. Anything else?
Are you intending on, or have you thought about, we're gonna send the instructions back with them initially, or just play it
I
by?
typically do not, and I will let them know that if they have a question about the law, the procedure for that would be to send me a note, and then I can recharge them on the law. I just get concerned that folks, this is intended to be interpreted as a whole, and I get concerned that folks, one person relies solely on page 17 and nothing else as a whole. I don't know whether I'm right or wrong. I know some of my colleagues send the charge back. But that's the way I am. All right, you ready for closing?
Yeah, a little PowerPoint here, it's just gonna have some, so it has the, thing ready whenever. I know it takes a little time to fire up.
Okay.
If we have it, will it just turn right on whenever we're ready for the first line?
It has a look, so like,
Okay.
And you can call the document you gave me, you give one to the court reporter.
I did not, Your Honor, I just passed it up to you, but I'll be happy to come up and hand it.
We made this one court. All right, ready?
Yes, sir.
All right, making sure, please, sir. Yes, sir.
Jury seated, Your Honor.
Thank you, sir. Good morning, ladies and gentlemen. Good morning. The parties have presented all the evidence in the case, and it's now time for the attorneys to make their closing arguments. Much like the opening statements, the arguments of the attorneys are not evidence in the case. Their statements are meant to help you understand the evidence and apply the law. You should disregard any remark, statement, or argument which is not supported by the evidence presented during the trial or the law that I'm going to explain to you at the conclusion of the argument. Stay ready to close.
We are. Hey, please go.
Yes, sir.
What is the value of a human life? That's usually posed as a rhetorical question, isn't it? What is the value of a human life? Can we assign a monetary value to a human life, to a human soul? Can we put a price on it like we can a bottle of water, or a bottle of motor oil, or a lampshade, or a fishing boat? Is that possible? Are some lives worth more than others? These are philosophical questions that people have been wondering aloud for ages. Do you remember that feeling of being a teenager? You remember what it was like when your body was new and shiny? Remember that? Remember time before work and bills and all the responsibility, being responsible for other people. You remember that feeling? You remember what it was like having that long road of life just stretched out before you and all the possibilities. Not knowing what they were, but just being excited for the ride. You remember that? Remember the last day of school? Remember the beginning of summer break, sleeping in, summer jobs, fireflies, fresh peaches? What about grandma's house? Slip and slides? Remember the smell of fresh cut grass? Beach trips, no responsibilities. How do you put a price on that? You remember that? How do you put a value on that? I've got a 15-year-old daughter and an 18-year-old son, and they're in that time of life. And if I'm waxing too poetic, it's because I'm envious at times of them and being in that stage and just having that whole long road of life stretched out before you and all the possibilities. Just an adventure waiting to unfurl, right? But if I could jump in a time machine and go back to them being 14 years old, I don't think I would, because I remember the difficulties of that time as well. I remember being 14, and a sad reminder that I'm not anymore is sometimes when I get a glimpse of the camera and I see my face up there, and I say, who the hell is that? Where do those wrinkles come from? Where did that gray hair come from? But I do remember being a 14-year-old boy. And if I could, I don't think I'd go back to being a 14-year-old boy. Because I remember the difficulties of being a 14-year-old boy. I remember the idea of trying to zero in on what is my identity? What is my personality anyway? Who am I? Where do I fit in? How can I be cool? To this day, I still remember things that I did that made me shake my head, things that I strongly regret, things that were ill-advised, things that were reckless and dangerous, things that were just plain stupid. It was not easy being a 14-year-old boy, and that was back in 1993. But that's what being a kid is. That's what being a 14-year-old boy is, to make mistakes and hopefully to learn from them, right? Isn't that what growing up is supposed to be about? I didn't look much like Cyrus. And I think that's obvious to everybody here. We grew up in different parts of Columbia. We had different experiences. We went to different schools. We grew up under different circumstances, different times. Seems that we were both skinny little 14-year-old boys from divorced parents trying to find our way. I remember trying to straddle that line between being a child and trying to figure out what it meant and where my place was in the world, and trying to figure out how to be a teenager. Trying to figure things out. And as I said, it seems that to me that it would be infinitely more difficult to be a 14-year-old in 2023 than it was in 1993. There are just things that exist now that were unimaginable back then when I was 14. But some of the broader challenges would have been the same. Where do I fit in? How do I fit in? This would have been that wistful time of life for Cyrus in May of 2023. He had just wrapped up 8th grade. We all know what comes next, 9th grade and high school and all the craziness of that. But right now, May of 2023, it's summertime. The first week of summer. What's better than that? How do you put a price on that? It's the best time of the year for a kid. There's still a few months before he has to deal with that crazy time of 9th grade and high school. Sunday, May 28, 2023, was Memorial Day weekend. Cyrus was fresh off middle school graduation, and it was summertime. Why does a 14-year-old have a gun? This was asked multiple times by my friend, known him since I was 14, Jack Swartling. But he asked that a number of times. And I suppose he asked that as a literal question that deserved an immediate, succinct, distilled, and simple answer. That was how the question was posed, that it is a very simple question and deserves a simple answer. Maybe it's not that simple, though. Maybe it's a much broader question that we as a society will eventually have to sit down and come up with real answers to and possible solutions to. Maybe it's a question with an answer that is so complex, it has so many layers, that it's so loaded that maybe it's not something we just figure out in a day. But it does seem, as long as guns have existed, boys have been fascinated by them. Required reading when I was in elementary school was Where the Red Fern Grows. And it was all about Billy and his gun and the exploits and the adventures. 10-year-old Billy and his rifle. Or, my favorite movies back then were Tombstone and Young Guns and Predator and Terminator. Just movies about guns and violence. Boys eat it up. I did. So many movies, so much imagery, so many music videos about guns. It's just, we're in America. It's part of life, and boys eat it up. You can't even get through December without Christmas Story and Ralphie and his fascination with the Red Ryder rifle, right? It's just a fact of life. And that was all before the internet. But again, we live in America, and to take that one step further, Cyrus and I grew up in the South. And we were blessed to grow up in the South, weren't we? And guns are just a part of life, are they not? A gun leaning up in the corner when I was growing up was about as exciting as a cast iron skillet on the stove or a butcher knife in the sink. It's just part of our life. And whether that's good or bad, I'm not here to talk about that, but guns are prevalent and boys gravitate towards guns, whether that's good or not. Was Cyrus right in having a pistol in his pocket May 28, 2023? No. Was it legal for Cyrus to have a pistol in his pocket, May 28, 2023? No. Has anybody indicated that it was okay or legal or right? No. Did he deserve to die? Did he deserve to die? I remember my grandfather letting me practice with a little .22 rifle. I remember being 8, shooting a .22 rifle. I remember my first single shot, 410 shotgun. I was probably about 12, 13 when I got that. I remember going up to the little cabinet just off the kitchen in my grandparents' house and finding a little revolver he had there. And I remember taking it down, and I remember going down to the pond and shooting a few shots. I was probably about 12, and I knew I wasn't supposed to do that. And I knew I'd get in trouble if I got caught. That didn't stop me. I remember all those things. Boys do things that are ill-advised and not always smart. That's part of life, though. We hope as we grow older, we learn some of these things. And we grow out of them. Did Cyrus deserve to die? Cyrus Carmack Belton entered that Shell gas station at 7441 Parkland Road, about 8 p.m., May 28, 2023. He had no way of knowing that he'd be dead in about 10 minutes. You see him enter the gas station. He is immediately asked to take his book bag off, a very fair request, and he complies immediately. He's not rude during the encounter. He does as he's asked to do. We see Alice check the facial recognition database once he comes in. We heard about the facial recognition database they employ at the Shell gas station. And then she went about her business, or pretended to act busy, while keeping an eye on Cyrus as he walked up and down the aisles. At some point, she ducks her head into the office where Rick is. What, if anything, she said to him is unknown. We don't know. But Alice and Andy continued to watch Cyrus as he walks up and down the aisles. Eventually, he goes to where the water bottles are. He had to know he was being watched, right? I mean, I don't think Alice was making it unknown, or she wasn't really disguising what she was doing. He took 4 bottles of water out, put 4 bottles of water back in. He's caught on camera from several different angles doing so. And cameras do not lie. Cameras do not make mistakes. It would have taken about 17 seconds to watch him at that water cooler if Rick Chow had decided to do that. About 17 seconds of his time. 17 seconds to confirm that he took nothing. The failure of Rick Chow to do this will cost Cyrus his life. Thousands and thousands of dollars of technology at Rick Chow's fingertips, and he chooses to act in anger. Cyrus would be a rising senior if he was still alive, entering his 12th grade year of high school. If Rick Chow had taken about 17 minutes to review the footage. 1, 2, 3, 4. 4, 3, 2, 1. As Cyrus turns from the water cooler, Alice and Andy begin asking him if he put a bottle of water in his pocket. $1, 114 pounds, 130 yards, 21 grams. Fight or flight. You've heard that term. It's a physiological reaction, right? It's ingrained in us since we were cavemen, I guess, basically. And it is an instinct, it's a reaction that occurs in situations where there is a threat. Okay? If Cyrus is a tough guy, right? If Cyrus is a thug, right? If Cyrus is a gunslinger, right? If he is that guy, okay? If he's that guy, now is the time you'd see it. Now's the time he'd pull that pistol out, point it. If he was that guy, right? He's not that guy. He's a child. He doesn't pull out his pistol. He doesn't cuss or disrespect anyone. He collects his backpack, he drops his head, and he walks out. If he was a fighter, now would be the chance for him to confront anybody. If he ever intended to use the gun, it would have been right here. But this is the moment where cool heads should prevail. Cool reflection should be what happened here. Reflection should have occurred. This is when adults should act like adults. This could have been it. He could have walked off. He would be a kid looking forward to senior year in high school. You have a mother and a father who would still have their little boy. $1, 114 pounds, 17 seconds, 1 second, 21 grams. An entire lifetime ahead, unknown potential, success, failure, redemption, decisions. We know the decision Rick Chow made. It's etched in time now. It plays back like a bad movie you've seen before. You already know the ending. He did what he did, and that's why we're all here today. Let him go. Just let him go. We don't need to be here today. Let the boy go. What have you got to lose? What is the value of human life? As of May 28, 2023, Rick Chow had owned and operated that gas station for over 10 years. This was not his first day on the job. Why not call 911? It takes 1 second. Andy said so himself. It takes 1 second to call 911. Better yet, why don't we review the videotape? If we think the boy took something, why don't we look at that videotape? Because then we'd realize we don't even need to call 911. He never did anything. We would learn that immediately. All this at your fingertips.
Instead, you choose to act in anger. You choose to make split-second decisions. And you're dead wrong. For argument's sake, there, let's say he had committed the abominable crime of stealing a $1 bottle of water. Let's say he did that, okay? Well, you remember the wall of shame? You remember the testimony about all the pictures all over the store of various people who had been suspected of shoplifting. And what we do at the Shell gas station is we take their picture because we have all these cameras that we can get all these pictures from, and then we put it up on the wall of shame. And that's what we do. We shame them. But also if they come back in, we can confront them. Why don't we put this little boy's picture up there then? I mean, if he stole water, let's just do that. That would have been a better option, right? Or we get all these pictures, let's send them into law enforcement. Looking for this guy. And by the way, we know exactly what he was wearing. And by the way, he walked that way down this dead end road. Shouldn't be too hard for you guys to solve. Anything would have been better than this. He chose to chase down an 8th grader. The boy was so terrified that he ran out of his shoe and continued running. The boy was so terrified, he's losing clothing. He drops his phone. He drops his mother's phone. But he continues running. Wouldn't that have been even another great opportunity for them to stop? Listen, we've scared this little boy so bad, he's come out of his shoe. Let's stop the insanity right here. Let's turn around. Let's take our butts back to the Shell gas station. What are we even doing anyway? Why are we doing this? But no, they continue tracking him, chasing the boy down. And then he takes that hard fall, hits the ground. What about right then? Wouldn't that have been a good time to be like, we're scaring this boy so bad that he's run out of his shoes. He's lost his cell phones. Now he's hurt himself. We've gone too far. We've gone too far. But no. 130 yards, 114 pounds, 390 feet, 1 second, 17 seconds, 21 grams. Why in God's name are 2 grown men, one armed, chasing a child, because that's what he is, 130 yards? Why in God's name? Devontae Bryant, he had to hit the brakes because he didn't want to hit. He'll come running out in front of him on Springtree. Dead set on catching that boy. He had to put the brakes on. He says he thought it was the police. I said, well, why'd you think that? He said, because one of the guys had a pistol. And they were chasing that boy. I thought that was the police. And so that would have been what Cyrus saw too. He doesn't know why these men are chasing him to begin with, why they're yelling at him. And now he sees one of them has a gun. And he's wondering, why are these people chasing me? What are they going to do to me? And he's running. And Devontae Bryant said he didn't have anything in his hand. Lori Carson pulled up too. Remember her? That's her in that BMW. A grandmother. She recognized immediately Cyrus was a child. She said he looked frightened. He looked scared. He said it looked like he needed help. He said he didn't have anything in his hand. Kennedy, Jasmine Broadwater, they saw him too. He didn't have anything in his hand. All of them had different angles to observe. None of them knew Cyrus. But they were all very clear. The boy had nothing in his hand. He had a backpack over his left shoulder, which you can see in the video, trying to hold his pants up while he ran from these men. But he had nothing in his hand. What does 130 yards look like? Well, it looks like this. It's a long distance. It's too damn long. It's 130 yards too long. 114 pounds, 1 second, $1, 21 grams. Cyrus was shot in his back as he ran away from Rick Chow and Andy Chow. He entered his lower back, just to the right of his backbone. He traveled upwards, you see. It went through his lung, you see. It entered the right ventricle of his heart. It came to rest there. And that trajectory tells us he was trying to get away to the very end, trying to run from danger. He died scared. He died bleeding to death. Rick Chow's face being the last one he saw. He died surrounded by strangers. Died scared on the side of a road in nowhere, America. He died young. He died because of Rick Chow. Shot in the back. Today, Rick Chow says, well, guys, I had to do it. I had to kill that boy. I had to chase him down, and I just had to shoot him. He says his son yelled gun, and he had to shoot. He tells you he was justified in doing it. And he says, well, if you're wondering why I shot and killed a child in the back, it's because of the doctrine of defense of others. That's what he says to you today. He was dead wrong on May 28, 2023, and he's dead wrong today. Okay. So what is the law of defense of others? There are 4 elements that the state has to disprove one of them, okay? But these are what would get you a charge and find that you would be justified in killing somebody based on the law of defense of others. If any of these are disproven, any one of them are disproven by the state, then he does not get that legal justification for killing. You understand? If you find any of these to not fit for him, he does not get the defense of others. Number one, okay? I want to be clear. He fails right off the bat. What is the number one element of defense of others? The very first one, that he fails miserably. Rick Chow and Andy Chow both must be without fault for bringing on the difficulty. Y'all remember those questions I asked Andy? And by the way, the other thing y'all get to consider is credibility of witnesses. Y'all seen people lie before. Y'all seen people tell half-truths. Y'all seen people waver before in questions they didn't really want to answer. Y'all seen that before in life. Y'all have a chance to sit back there and talk about whether y'all found Andy to be a credible witness or not. But one thing I asked him is, Andy, Cyrus is still alive if y'all stay in the gas station, right? He said, yeah, you're right. But then they decided to ramp it up. They brought this difficulty on, okay? One of his lawyers said, well, you know, Cyrus would be alive if he didn't have a gun. And I said, you would never have known he had a gun, would you? If you just kept your butt in the shell station, kept doing the work you were doing. Stay behind the cash register. And Rick, stay back in the, what do you call it, your surveillance room back there. Why don't you just stay back there? Why are we running 130 yards off our property? Even after he loses his shoes and his cell phone, why aren't we just stopping on the property? If we need to see which direction he goes in, well, we see him running up that straight road, and we know it's a dead end, and we got all these pictures of him. Now we got a cell phone, we got a shoe, we got all these pictures of him, we got his clothing. Cell phone, shoe. Why do we bring on the difficulty when we don't have to? But right off the bat, defense of others fails. Prong number one. A grown man with decades of experience chose to turn suspicion into pursuit and pursuit into gunfire. We fail immediately. But if we were to consider going on, he fails all four of them. Let me just walk you through it just to be clear. But if any one of them fail, he does not get that defense. But number two, Rick Chow must be under the belief or have a good faith belief that Andy Chow was in imminent danger of death or serious bodily injury, harm. We saw that a fall and the after effects of it, it was such a violent fall that it led to those wounds to his shin. He goes face down into the ground with various witnesses said. And then marker AA right there. That would be the laser pointer, the flashlight we heard so much about. That is an interesting marker because you know what that tells us? A couple things really. It tells us where Cyrus fell and hit the ground, but it also, along with those wounds to his leg, shows us how violent of a fall it was. That would be where he hit the ground, and the only way this works is if his gun comes out of his hoodie, hits the ground so violently it dislodges the flashlight, and that's where it came to rest. Ladies and gentlemen, if you are a 14-year-old boy, and you know you're not supposed to have that gun, and you're being chased by people, and it spills out, the very first thing you're going to do is pick it up and continue running, which is exactly what Cyrus Carmack Belton did. He was trying to get away. But as you see right there, that would be where he fell. And we know he continued running because his body's found past those two poles. But what is further up towards where his body came to rest? AB right there is that shell casing. That is approximately where Rick Chow stood when he fired the weapon. So even after we see where Cyrus fell, Rick Chow is still advancing towards him, still moving towards where he ultimately came to die. I don't know how you describe being in fear of this boy and being terrified of him, but even after he falls and you supposedly become aware of a gun that spills out of his pocket, you continue to advance towards him. How do you say now that you were in fear of him? And would a reasonably prudent person have done this? Would a reasonably prudent person have even left the shell station? The answer is no. He fails 2, and he fails 3. So finally, Andy Chow must be shown to have had no other probable way to avoid the danger of death or serious bodily injury than to act the way he did. Okay? I don't understand how you can ever say I'm retreating when you were the one chasing somebody, chasing them off your property, chasing them 130 yards down a road that you don't belong on. How do you then say I was retreating? No, you are advancing. You were the one bringing on this difficulty. You started it and you're the one who continues it. Rick Chow fails all 4 prongs of defense of others, and he fails spectacularly. We only have to prove one. Number 1, he fails right off the bat. I submit to you, he fails all 4. This would be a shot by now. You know, we spent a lot of time. I know it's been boring at times trying to orient you guys with the landscape, but it is important really to kind of have a general familiarity with this area we're talking about. But if we're looking at this picture, which is an evidence, y'all seen those poles right there a number of times. That's kind of a good marker. You've seen this drainage ditch right here on the bottom where the backpack was found. That's another good marker. Behind us will be the Shell gas station at Park Lane Road, and forward is just a dead end. This would be approximately where that laser flashlight attachment would be found. But again, that's where reason tells us that Cyrus fell. And the gun apparently hit the ground hard enough to detach the laser flashlight. That's where that was found. A little bit further up again, past where he fell, that means Rick Chow is still advancing past where that boy fell and continues chasing him with his gun. That's where the case is found, right there, the green area. Behind those trees, there's Brad repairs right there. That is where we know from the body camera that's where Cyrus comes to rest. That's where he dies. I mean, just on the side of the road, nowhere, South Carolina. Shot on the side of the road like a dog. Surrounded by strangers. Mother not there. Grandma not there. Scared and alone. Murder is, in South Carolina, statutorily defined as killing of another person with malice aforethought. Okay? What is malice aforethought? Judge is going to define malice for you. This is malice. You see this right here? Y'all see that? Look at it. This is what malice looks like right here. is hatred, ill will, or hostility. We know how Rick Chow feels about shoplifters. Okay. He has devoted a large amount of space in his store to advertise shoplifters and identify shoplifters. He doesn't like them. Malice is ill will or hostility towards another person. It's the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury under circumstances the law will infer evil intent. When does malice need to form, and when does it need to exist in the mind of Rick Chow? The judge will tell you it does not, malice forethought does not require that malice exists for any particular time before the act is committed, but it must exist in the mind of the defendant just before and at the time of the shooting. Okay? Therefore, there must be a combination of the evil intent, the prior intent, i.e. chasing a boy up the road with a gun at your side, and the act, shooting. How can malice be shown? There are two types of ways it can be shown. It can be expressed or it can be inferred. They're not different, but just the way they may be shown. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. Malice can be inferred from conduct showing a total disregard for human life. This is malice right here. Y'all see malice? This is what malice looks like. Shot to the back tells the story better than any witness ever could. The state must prove their case beyond a reasonable doubt. This is the standard of every criminal case from here to Seattle, all across the U.S. The state must prove its case beyond a reasonable doubt. What does that mean? Does it mean beyond all doubt? Does the state have to prove a case that leaves everyone saying, I have no doubt about anything anymore? No. It means that if you have a doubt that is reasonable, whether he's guilty or not, do you have a doubt that he's guilty? If you do, is it reasonable? Is it based on logic? If it is, then you should find him not guilty. That's just the law. That's how it's always been. But if your doubt as to whether or not he did what he did is not reasonable, or your doubt is not really logical, you must find him guilty. Does that mean you have to be 100% certain about everything regarding this case? It does not. The judge will tell you there are very few things in this world we know with absolute certainty, and in criminal cases, the law does not require proof that overcomes every possible doubt. He's going to say, if based on your consideration of evidence, you are firmly convinced. I put that in bold because to me, it's the best way to understand beyond a reasonable doubt. When you go back there and y'all are talking about issues or what you remember about specifics of the case, just ask yourself, are we firmly convinced? Let's all take a poll. Are we firmly convinced of his guilt? And if everybody raises their hand, then you find him guilty. That is how you determine whether or not there's reasonable doubt or whether there's proof beyond reasonable doubt. Are we all firmly convinced? Remember those two words. He's going to say it twice when he reads those instructions to you. Firmly convinced. So when y'all get back there and y'all say, what was reasonable doubt again? You say, well, I remember Dale saying firmly convinced. That was what we have to decide. Are we firmly convinced? Cyrus will forever be 14 years old. It'll always be the beginning of summer. Ninth grade in high school, they'll never come. You won't get the chance to catch the eye of a pretty girl. He won't get to feel rejection either. He won't be at the prom with his classmates. He won't have a chance to be cool or to take that winning shot. He won't have the opportunity to be a loser. He'll never get the chance to figure things out. He'll never feel his grandmother's kiss on his forehead. He won't get to drink that beer when he turns 21. He'll never catch snowflakes on his tongue again. He won't get to feel the sun on his face that first warm day of spring. He'll never get to find his way in this world that can be so cruel, but so beautiful. He won't be like this 14-year-old boy and look in the mirror and see these wrinkles and this gray hair that just kind of came out of nowhere, and be able to trace them and think back of the memories and the experiences behind them. He'll forever be 14, alone and scared, running up that road, trying to get somewhere safe, but never making it. And solicitor Stephanie and Weston and I, we walked that stretch of road on Spring Tree a dozen times or more. The air, it just feels heavier. The energy it's off. The tragedy of a life cut short is just burned into the surroundings. I can't explain. And the question isn't, why does a 14-year-old have a gun? It's, why is an armed 57-year-old man chasing a boy 130 yards, knowing how scared he is, and then shooting him in the back? You know this is wrong. You know it's wrong. You're dead wrong about that water. Mr. Chow, Rick Chow, is dead wrong about this. 14, 130 yards, $1, 1 second, 21 grams. In the early 1900s, there was a doctor. He thought he could measure the weight of a human soul. He thought it was possible to determine the physical weight of a human soul. He measured 6 patients just before and then right after death. And in one of them, he found something interesting. One of the patients, he determined there was a difference of 21 grams. And so he determined, based on that experience, that the human soul weighed 21 grams. 1 out of 6, very small sample size, and it wasn't well documented, but still it became a popular concept that the human soul weighs 21 grams. We know that's silly today in 2026. What does our spirit weigh? Does it weigh 21 grams? No, we know that's silly. Just like we know a human life, there's no value you can put on it. It's worth way more than silver and gold. It's worth way more than this. You know it. Ladies and gentlemen, you have a decision to make. I thank you for your time and attention this last week and then today. I thank you. There is only one verdict here that speaks the truth. There is only one verdict that addresses what this man did. and what this took. One verdict. That verdict is guilty. That's what I ask you to do. Find Rick Chow guilty of unjustly taking Cyrus Carmack Belton's life. Find him guilty. That is the only verdict that speaks the truth and speaks to the evidence in this case. Thank you.
That's right. All right, yeah,
We'll take about a 10-minute break. The technology and stuff sorted out. All right, ladies and gentlemen, we're gonna take a short break. We'll be right back with you, about 10 minutes, and then we'll discuss the case, or anything of that nature. We'll see you shortly. All right, we'll be at ease for about 10 minutes.
Hi, everybody. I don't have all my lights on. Hello, good morning. That was not a terrible argument. I'm just going to say that. I didn't agree with everything that he said, but I liked his closing argument. Like, he cued the violins many times. He drilled it into their head that you just have to be firmly convinced, not absolutely without a shadow of a doubt. So they're going to remember those two things. Sue is convinced. Sue's convinced. Now, StreamYard has this new thing where you can add a poll, and I did that, but I don't know where it's at. Is it in the description of this video? I have no idea. So I did put a poll up in this video somewhere. It must be in the description. But what I said was, what would your verdict be? Would it be manslaughter? Would it be murder? Murder, then manslaughter. Manslaughter is a lesser included offense. If he's found guilty of manslaughter, he could serve anywhere from 2 to 30 years. And the difference between those two charges is intent. The jury's going to have to decide, was this act intentional? Was it done with malice aforethought? Did Rick have the opportunity to think about what he was going to do that day? Now, he was carrying his gun as a sidearm in a holster, and I felt like he didn't do that just for this. Like, this is something he normally does. We don't know that for a fact, but I suspect so, that he normally carries this sidearm. So, hi, Julie. I agree, guilty, but the storytelling is over the top. He'll never feel snowflakes on his tongue. That was hilarious. Oh, God. Neither will I, because I don't stick my tongue out for... Okay. Anyway, it's not a funny thing. I'm sorry I'm laughing, but I try to keep these things a little bit on the light side here because it is such a tragedy. Hold on. Oh, okay. Because it is such a tragedy. I honestly don't know what I would do as a juror, because I think Mr. Chow was wrong. I think Andy Chow was wrong. I think Alice Chow was wrong. I think Cyrus was wrong. Nothing went right here. Absolutely nothing. And I gotta believe that I'd go with manslaughter, where he didn't do this with malice aforethought. I don't think when they chased him, I don't know really what their intent was. What was the outcome you were hoping for when you chased him? Like, You already had a description of him. You already suspected that he stole something. You knew that, like, the prosecutor was right. You knew the direction he was going. So what did you think was going to happen when you caught up to him? So you were just going to take the water back and everybody was going to go their separate ways. I don't understand what their goal was that day. Julie says, here, let me put this up so I can read it. I've got my old glasses on and I can't see a damn thing. His anger ignited stupid choice of using all that camera equipment, and he decided foot pursuit, prosecute with evidence on the film. Yeah, I know. So I didn't know. See, I was always wondering how Rick knew about this. Was he watching the surveillance footage? Well, according to the prosecutor, Alice notified him. I did not see Alice go back into that office, but she was like all over that kid, like following him around like a hawk. Like, why? Because a black child entered your store? That's so racist. I'm sorry. It's just racist. Like, and then the irony of it all is there's this one eyewitness who's watching the confrontation between Alice and Andy and this guy about the water bottle, because he's standing there waiting to buy a lottery ticket. And he's got this hoodie on, and the back of the hoodie has handcuffs on it. I thought that was funny. Anyway. Boy, I'm just, Joanna, she says, I'm thinking murder. One, you're not allowed to legally chase a shoplifter outside. That's the cop's jurisdiction, not yours. Well, the lead investigator said it's not illegal to chase them, but you need to use your common sense when you're doing something like that. And I think common sense went out the window with everybody in this case. Gone. And Sue made a point earlier, could they come back and prosecute Andy? Everybody has said Andy was at fault too. So it would be a harder prosecution. But I think they could get a conviction on Andy too. And they may, Sue mentioned that in the case out of Florida, it's escaping my mind. God, how could it escape my mind? Donna Adelson. Yeah, they prosecuted the hitman, and then the go-between lady, then Charlie, then Donna, and we're still waiting for Wendy to get indicted. But you can go after somebody one at a time. So Andy's not out of the clearance yet. Like he could be prosecuted. And more than one person has said he is at fault in this case, including the lead prosecutor said Andy is not without fault in this case. So we just got to wait and see what happens here. But do I think we're going to get a conviction? I think so. Yes. What is it going to be, murder or manslaughter? That's the question. And if you can find the poll that I put up, because I don't know where it went. Joanna says, it's the South. Everyone has a gun. My florist in Texas carries a gun. Shoot a person for flowers. You guys know how much I hate guns. In fact, there's a day coming up. I think it's this weekend. It's called Wear Orange. If you're against gun violence. So I'm going to be wearing orange on Sunday. If I don't even know if I own anything orange, but I'm going to find orange because I hate guns. And I got to believe that, if you're carrying a weapon, you're assuming the risk that if you pull that weapon out, someone's going to defend themselves against you and you could get shot. You're just assuming that risk. If you're I don't care if you're 14 or 45, if you think you are mature enough to carry that weapon, the consequences go with it. Andy didn't have a weapon. Rick was carrying a weapon and now he's facing the consequences. Cyrus was carrying a weapon and now he's facing the consequences of that. how would this have ended if no one had a gun? No one would be dead. Yeah. Let's just say that. Okay, I need to shut up about gun violence because I'm in the minority when it comes to that. I don't care if it's the South. Put your guns away, people. Put them away. Put them in a safe. Parents, somebody, I mean, he didn't buy that gun legally. He was not legally in possession of that gun. How did he get the gun? Was it his parents' gun? Did he buy it from someone? Where did he get the money for that? Are you not paying attention to your 14-year-old son who's walking around your house with a gun in the front pocket of his hoodie? I will say that 14-year-olds can be pretty sneaky. I will say that. Like, he could have hid it and they would never have known if he got it from some other source. And that could be. I mean, nobody, who knows? And then I heard the prosecutor talk about a grandmother. So this kid may not even have parents. This was not a good neighborhood. This was a low socioeconomic area that he lived in. So circumstances may not have been the best at home. And anyway, they're back. I'm going to shut up because they're back. So here we go.
Whoa, wait on the defendant. Yeah, good answer.
Drew, see you, Honor.
Thanks, sir. Ready?
Yes.
Yes, sir.
I remember growing up and watching shows with my father. And I'm old enough to date myself a little bit that we would actually listen to radio shows. And one of the radio shows that we would listen to quite often is a guy named Paul Hurley. And what he would do is he would tell stories. And in telling stories, what he would do is tell a story that he thought that everybody actually knew. He would tell a story and he would give details of a story that he thought that everybody actually knew already. And he would tell it, and he would tell it in his interesting way, but what he would do is intentionally leave out parts of the story so that people would be a little confused because they'd heard the part of the story that they thought that they knew, but he would leave parts out. And then he would take this huge pause after he was done and everybody think it was over, and then he would say this famous line. He would say, and now it's time for the rest of the story. And then he would spend the rest of the show telling the listener the rest of the story that they did not know. He would do this because he understood people. He understood that we are a generation of people who simply listen to headlines, listen to flashy things, and don't hear the rest of the story. He understood that if he could tell just small parts of the story in the way that people thought that they understood them and didn't hear the rest of the story, then they would believe things one certain way. And the way that he did it was fascinating. It was interesting. People started to understand that that's the way we have to start listening. Because if we only hear part of the story, then we can never get to the truth. And so as we sit here and get ready for our closing argument, all we're going to do now is tell you the rest of the story. I will tell you wholeheartedly, and this might come across as a shock. I agree with some of the stuff that the state of South Carolina said. When they got done with their closing argument, folks next to me said, do you want to take that dollar down? And I said, no. Because let me tell you with unabashed honesty, they are 1,000% right about the following statement. If Rick Chow executed a human being over a $1 bottle of water, enjoy hell. Let's make that clear. If Rick Chow shot a man in the back stealing $1 bottle of water from his store, you do what you will. Because there's nothing to justify this back and forth. Was he right? Was he wrong? It doesn't matter. Taking a human life over a bottle of water is absolutely ridiculous. It's wrong under any way that you could possibly look at it. And that's why the state has gone out of their way to put this $1 bottle of water up, to put this picture up, because they want you to believe that this is what this case is about. The rest of the story. It has nothing to do with this water. It doesn't. Because if that was what it was about, this wouldn't be a complicated case. As we sit in front of you, the things that we have to talk about is we have to break down everything that we have watched in this case. We need to break down what the state of South Carolina has presented to you. And as we break it down, we can break it down inside of 3 classifications, what they put on the scene. They put on what they call eyewitnesses. They put on investigators. And they put on experts. You remember? Those are the 3 things that they have given us. So first, let's talk about the eyewitnesses. And the reason I want to talk about the eyewitnesses first is, remember, and I wrote down a quote that the state said, cameras don't lie. For 17 seconds, you could have played the camera. For 17 minutes, you could have played these cameras. If you remember, these witnesses got on the stand, they sat in front of you, and I asked them questions. They looked directly at you. They were talking about what they remembered. They were talking about their memories and how important that is. And then I started asking them questions from right there. You remember? I said, no, I'm not trying to be rude, but I remember you talking to 911. Do you remember that? Yeah. And you said something different to the 911 tape that you're saying right there today. I asked another person, isn't it true that we don't interview witnesses together because they can get their stories together and their brains could get something that didn't really happen? Yeah. And that's on video, correct? Cameras don't lie. And they called 911, and in the 911 call, they said they didn't see anything, correct? Cameras don't lie. But don't you remember, and I asked one of the witnesses, isn't it true that you told them something and they said that was completely impossible? Well, yeah. And then they met with you, they talked to you, they interviewed you and put you on the stand and you told something different. Cameras don't lie. So why are we sitting here and not watching those videos? Why didn't the state give you the 911 calls? Why didn't they give you the videos? Why didn't they give you the information? If cameras don't lie. The rest of the story. I talked to one of the investigators and officers as he took the stand. Remember, we asked him, what is important as an investigator? It's important to get the facts. It's important to get the information. It's important to get the evidence as close to the incident as possible. So we can do what? Remember the question I asked him? So we can give all the information to the jury. The rest of the story. Because what we don't want to do is subject and put our emotions in there, our personal beliefs, our subjective decisions. That's what's happened. The rest of the story. But for some reason, the state of South Carolina doesn't want to give it to you. One of the witnesses took the stand, if you remember correctly, Detective English took the stand. You remember? One of the first ones they put on. And they put the videos up on all of these screens, all this technology that the state of South Carolina has. And they put up all of it. And one of the clips they put up was of Rick Chow's statement. You remember? And they played it, and it said, my son saw, I didn't initially see my son that he had a gun, so when I looked at his hand, and then what did that officer do? He just walked away. We knew there was a second part of the video. Cameras don't lie. It would have taken how long was the quote? 17 seconds to play it. Cameras don't lie. And what was the next question from the state of South Carolina? Isn't it true he didn't tell you on that scene blank? Cameras don't lie. So we literally had to make sure you knew the rest of the story. And what did we do to tell you the rest of the story? We brought that other officer on to tell the rest of the story. And you remember, it went right together. The rest of that statement. My son saw, I didn't see it initially. My son alerted me that he had a gun. So when I'm going to go talk to his son, that's when he walked away. And then the statement kept going. Look at his hand. He actually had a handgun in his hand. The rest of the story. He got up running, then my son yelled, he's got a gun. So when I watched, there was a gun in his hand. That would be some important information for the state of South Carolina to tell you. But they needed to be about $1. They need to scare you. They need to make you afraid. They made you think the great Rick Chow, this evil human being over here, killed a man over $1. And that is disgusting. That is awful. That is abhorrent. But that's not what happened. The rest of the story. We don't want to tell you the rest of the story because if you hear it, then you get to make an intelligent decision, and we don't want you to make an intelligent decision. We don't want you to hear the 911 calls. We don't want you to watch the videos. We don't want you to hear what Rick said at that moment, at that time, without a lawyer, without anyone telling him what to say or do. We had to play those. The rest of the story. And as we get in there and we listen to this and we go through all of this information, it becomes incredibly important. We then had investigators take the stand. You remember the questions I asked of the investigators and why they were so important. The state of South Carolina, for you to make a decision, has come in front of you and said, put witnesses on the stand. Guns aren't that bad. 14-year-old kids have guns all the time. And they had witnesses literally with their hands on the Bible looking at you, talking about, guns are prevalent. It's not that big of a deal. That was the testimony. I didn't make that up. That was the testimony that they submitted. Do I think they believe any part of that? Not a line of that. But they have emotion. They're upset. And they want you to believe it's about a bottle of water. It's not. The rest of the story. And then there was an expert who took the stand. You remember? I asked her a very directly question. I had her sit right here. She stood in front of you as if she was Rick Chow. And I showed her what we said Mr. Belton could have been doing. And what did she say? Yeah, that's possible. The rest of the story. She described the bullet path, back to front, right to left, slightly upward. The rest of the story. We got to avoid all of that because that changes our narrative. So now we go into what they did present. And let's talk about the part of the case that we're all wondering about, the thing that everybody's there, and if it's in your gut, it should be in everybody's gut. And they spent their entire case. Their case was a day and a half, and most of it they spent it on one part. chase, the chase, the chase. They shouldn't have done it. They shouldn't have done it. They shouldn't have done it. You remember one of the witnesses, the investigator, got on the stand, and I had to ask him the question, is there anything illegal about that? No, sir. But that's what they're talking about. Well, common sense. We don't want you to do it, but it's not illegal. That's an important distinction to know. This is a store. The testimony was they've owned it for 11 years. Margins are small. You've seen the wall of shame. People have shoplifted. People have stolen. Chased them. I've been stolen from. I chased the people to Georgia, flat out. It's their property. They're emotional about it. And that's why he ran after it. The question isn't, do you think it's right? The question is it legal? And then you go to the second part of it, is it legal? If it was illegal, don't you remember Andy Chow sat up there on the stand? And Mr. Scott got right in his face, and he was yelling at him, and he was going angry with him, and he was saying everything to him. But the one thing he didn't say to him is, and you have been charged with following this young man out of the store. And you are criminally liable for following this young man out of the store. Because he's not. He's not liable. He's not criminally liable. He has not been charged. And he did not do anything wrong. But when you Monday morning quarterback and come back and look at the situation and say, well, why? You know what? They could have done this. They could have done this. They could have done this. Because that's what the state's case is. Think about it. How many times did you hear throughout the course of this trial the great state of South Carolina say the following sentence? They could have done this. 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 They don't have evidence to offer, but they have fear, passion, emotion, and they want to get that out of you. They want that fear, passion, and emotion, and for you to ignore the law. We do not get to take the law the way that we want it to be. We take the law the way that it is. Let me say that again. We don't get to take the way that we want it to be. The solicitor can't say, well, I want it to be illegal for a shopkeeper to go out of the store. Shopkeepers should not be able to follow somebody. That's what I want. Andy, that's what I want. That's not the law. And then there's one last part that he, for some reason, has ignored. Let's say one of you, just one of you for argument's sake, are sitting back there and you say, you know what? I think they are at fault in bringing on difficulty. It may not be legal, it may not be illegal, but I just don't like the fact that they follow him for 130 yards. I do not like the 130 yards. I do not like the 130 yards. Well, the judge is going to charge you on something on the law, and it's called withdrawal. Let me explain that concept to you. Let's say one of you start a fight. Let's say I start a fight with Mr. Scott. And let's say I go up to him and I say, I'm going to get you. I'm going to take you down. I'm going to hurt you. And I start the fight and I come at him. And I'm about to hurt him. And then all of a sudden I say, you know what? This is stupid. I don't want to do this anymore. And I turn around and I'm like, I'm over this. And Mr. Scott brings a knife and comes out. Well, according to their theory, I got to let him stab me. According to their theory, I got to let him hurt me, even though that I have withdrawn. Well, that is the law of withdrawal. If an individual says, if they withdraw by words or actions, the right to self-defense is back on the line. The rest of the story. And don't take my word for it, the judge is going to instruct you on the law, and that's one of the things he's going to talk about. So when we talk about the chase, when we talk about why did they run out of the store, when we talk about they shouldn't have gone out of the store, as I told you, you legally have a right. The officer, their own witnesses told you, they legally have a right. This officer with 25 years of experience, dealt with shoplifting, dealt with this. He says, we prefer you not, common sense. But then there's a last part of that wasn't on their little pretty board. The right to withdraw. When Andy Chow testified, when he told you what happened, he said, I was following him. I was running after him. He fell. When he got up, he had this gun, and then I went this way. And as his hands were up, remember I asked him directly, the gun was still pointed at you? Yes, sir. You were looking directly at the barrel? Yes, sir. And then what did you hear? I said to my dad, he's got a gun. He's got a gun. And then what did he say his dad said? Drop it. Stop. Drop it. No. There's nothing more withdrawal than that. When he is yelling, stop it, drop, no. That's a withdrawal. That's saying, look, man, you got it. You got the gun. I'm good. They love to say that everything could have stopped. He could have put the gun down. But we have to ignore that because that's not part of their story. We cannot tell that part of the story because it's not necessary. And when we tell this story, you might look at me and say, oh, Mr. Kent, that's some creative lawyering. No. That's why we played the 911 tape. And in the 911 tape, you heard. That's why we played Andy Chow's interviews. Didn't hide it. What do you say? Takes only 17 seconds. What was the other quote? Better than any eyewitness ever could would have been a video. That's what the tape said. Better than any eyewitness ever could. So why wouldn't you play them? Because it would have been better than any eyewitness ever could. Now let's talk about the fact we talked about the store and the things that happen inside of the store. And there might be questions, why did you guys keep bringing these things up? If you remember, I had the officer on the stand. Great officer, great investigator, great person. But I had him on the stand, and I was talking about firearms and 14-year-olds, and he went back and forth because I don't think they wanted to admit that this is a problem. But the thing that was the most important is I asked him about suspicious behavior. Did something look weird to you when you went back? And he didn't want to admit it. But use your own common sense on that. I asked him the direct question, looking back through your investigation, as you have gone through and looked at the full file and looked at everything now, do you find it weird, odd, suspicious that a young man would go into a gas station without any money, with an empty book bag, bullet in the chamber, and then was looking like he was taking stuff off of the counter? I don't find that suspicious. I find that answer suspicious. The reason we brought this up is not to suggest I don't know what Cyrus was doing. I don't. But use your common sense and ask yourself, that does seem strange. And the reason we bring that up is that would explain why Andy, who was sitting at the front counter, looking back, is watching this and going, he's acting strange. He's acting weird. He's putting water back up, water back up, water back up. It looked weird to me. And then he came up to the counter with his hands in his hoodie, and there looked to be something heavy in there. I didn't know what it was, and so I asked him, and he did this, and it looked like there was something heavy in there. It was the gun! Did Andy know it was a gun? Absolutely not. But you can understand why Andy would have said there's something strange going on. His behavior, something in a pocket, going weird with the water, that's what was strange. So that is to explain why Andy made the unilateral decision that there was something strange going on here. And then Andy made the decision to follow him out of the store, chase him, run after him, whatever you want to call it, but he made that decision based upon a reasonable belief of what anybody would have thought something strange here. I asked the officer, again, about the suspicious behavior. That 24 hours, less than 24 hours before he came into the store, he posted this on his social media. You remember? I asked him about it. And not only was it this was a clip from a video in which he was pointing a gun at a screen with a laser and a flashing light on his Instagram story. You put all that together, you can explain that someone's behavior would have been a little strange. And he would have had that firearm with the light on it. It makes sense. And so that explains why Andy, and don't forget, when the officer was talking and asking questions and he went back to the back to look at that video surveillance that they keep talking about. Do you remember how many times? He's like, I had to look at it 2-3 times. I had to zoom in on it. He had the technology to see what was taken. Andy had one time. And from his vantage point, something was going on. And so he followed him out the store. He ran after the store, whatever you want to call it. The rest of the story. And then Andy testified that he threw stuff out of his pocket. You remember Mr. Scott said, you did not testify to that. I had to show 4 different times where Andy said he was throwing something out of his pockets. 4. And so he went after him. He followed him. He chased him. He's going after him the entire way. And they're right. He fell. He fell hard. And now they're saying, well, he would have naturally picked up his gun. That's why this is important. He's running. Or let's put it this way. Let's try two. One, he's running and it's in his pouch. He falls. The light goes off, but the gun stays in the pouch, I guess. Or the gun comes out, yes. I don't know. But he picks it up. And that's what they just testified to. He picked it up. The judge is going to tell you something else about defense of others. You have the right to act on appearances. And you have the right to be wrong. He's going to tell you that. They just told you. He was running, he fell down, and he picked up a firearm. All this stuff, all this back and forth, he 100% from the state's mouth, he picked up that firearm. You have a right to be wrong. You have a right to act on appearances. And that's what the judge is going to tell you the law is. And that's from the state. I want you to think about that again. Gets up. Medical examiner, shot, back, angle, pointed. Right to act on appearances. Rest of the story. Or take it another situation. What makes sense? Maybe the light's on the fire. And then as he's running, when he falls, that's when it comes off. We don't know. Because the burden of proof is on the state to prove what happened in that situation. And they've just admitted the one thing we know for a fact is he picked up the firearm. That's from them, not from me. That was their admission. And then as he picks up the firearm, then we have to go with Andy's testimony. And he's right. If you don't believe what Andy says, if you think Andy is 100% a liar, you can stop right now. Andy's lying. He made it up. This is completely not true. The gun was never pointed at him. He never saw this silver barrel that he only would have seen after he saw Discovery. He never saw it. And then let's take that one step further. Not only that you must believe that he is a liar, you must believe that Rick Chow is the most creative, smartest person in the history of the world. He is clairvoyant, if you will. Let's give him an Oscar. Rick Chow was able to decide, you know what, I'm going to kill this boy. I need to figure out when he's going to come into the store, when he's going to have a gun, when it's going to be in his pouch. I need to make sure that Andy sees it. And then I need to make sure Andy follows him for the direction. So I need to make sure Andy calls 911 and says exactly what I want him to say. I need to make sure Andy says the exact thing that I'm going to say at the exact time. Because that's what would be necessary to believe the state of South Carolina's case. That Rick Chow set all this up in motion to execute a shoplifter. The people he decides, needs, has to help him make a living. It doesn't make any sense. And if we take this one step further from the state's theory, Rick Chow is so pissed off, so damn angry about this shoplifter, hates him so much that he executes him. Why not shoot him when he gets out of the store? Gun's already on his hip. Why not walk out of the store? Shoplifter, $1, he stole, shot. Shoplifter, 10 yards, shot. Shoplifter, 20 yards, shot. 30, 40, 50, 60, 70, 80, 90, 100, 110. Why wait 130? Unless something changed. What changed was somebody pulling a gun and pointing it directly at his son. That's what changed. If he wanted to execute Cyrus, he could have done it right outside of that store. But we have to ignore that because that would be part of the rest of the story. Use your common sense and listen to the evidence, but listen to the witnesses and listen to what they have told you. Murder, as the state has told you, is the intentional killing of another human being with malice aforethought, without self-defense. We have just showed you self-defense and defense of others. The state has melded a little bit of those theories together, but you need to make sure that you understand. One, without fault and bringing on the difficulty. Again, I've explained to you that you have a legal right to follow somebody. Whether they like what the law is, that's what it is. And as you're going through that, then you have to talk about imminent danger. And this is from the eyes of Andy. And they're trying to mix the two other things together, but it's under the eyes of Andy at this point. As Andy, does he have a fear of imminent danger? Was a gun pointed at Andy? Would Andy, who had withdrawn from the conflict, you got it, I'm over this? No. Would Andy have had a right to point the firearm and save his own life? Reasonable person. A reasonable person in the same situation, what would they have done? And we can take that two ways if we want to argue the state's theory. Way one, Andy, gun pointed at you. Would he have had a right, as he was sentenced, remember that knife in the back situation? Andy would have had a right to fire to save his own life. But more importantly, the reasonable person's situation, Rick Chow would have had a right and did have a right to save his son. The strongest evidence that was given in entire this case when the officer got on the stand and I asked him that question. And I said, have you ever fired your firearm? No. Have you had a firearm pointed at you? Yes. I didn't fire. What if someone was pointed at your loved one? Yeah. I asked that same officer the situation when officers are chasing somebody and you chase them incorrectly. Remember we asked them that question. You chase somebody incorrectly, what happens? We chase them incorrectly, it does happen. And what would happen if that individual pointed a firearm at you? Remember the example he gave? If someone pointed a firearm as I'm chasing them incorrectly, well, I would tell, and they turned around and pointed a firearm at me, I would tell them, stop, drop it. And if they did not drop it, I would fire. It sounds eerily familiar to this case. And that's some of the rest of the story that the state of South Carolina, for some reason, has chosen not to tell us today. And then we go, duty to retreat, or can you retreat? As a person is pointing a firearm at you and you're pulling backwards and someone is saying, stop, no, don't. That's what duty to retreat is. No one turns and runs. The judge is going to tell you, as I mentioned, as we're talking about self-defense, and I've said it several times, you have a right to act on appearances, and you have a right to be wrong. So as we sit here and we're in Rick Chow's position, we're wondering what Rick Chow is doing. As we've heard this testimony, Rick Chow sees a gun pointed at his son. His son says, as you heard, I was afraid, I was terrified. He's got a gun, he's got a gun. So Rick Chow in that situation stands in the place of his son. This case is not about a dollar. This case is not about a shoplifter. This case is about a father who sees a gun pointed at his son and had to make a decision. I hate it. I did. I hate that a young man lost his life. I disagree with the state's theory on it's not that big of a deal that kids are going around with guns. I hate it. It is a problem. And it is a problem in this case. I hate that we have sat here and tried to make this about something that's not. I've listened to the state of South Carolina's opening statement talk about Cyrus's age, his future, and I understand all of that. I do. The one thing that does not know Cyrus's age is that gun. The gun doesn't know how old he is. And when a gun is pointed at somebody, you have an option. As we sit here and talk about this case and how important the details are, that if you step back and look at something one way, it's completely different. And as you get closer and you look at it more and you look at all of the details, you'll never see it differently again. And so what I'm asking you to do is focus on the details. I wear this suit all the time in trials. People say, oh, you always dress so flashy, but you're not flashy today. I wear this suit all the time because it reminds me that details are the most important thing that can happen. It actually has my name and the pinstripes in it, because when you look at it, after realizing it's not just a pinstripe suit, it actually has my name just right down the middle. And I look at it and it reminds me in cases that if you don't take your step back and look at things in full detail, you will miss it, like the state of South Carolina has, and they want you to miss it. We have to focus on important matters. We have to see the full story. You have to ask yourself the question, why don't they want me to know the full story? And then finally, for the state's case to make any sense whatsoever, we have to go back to our withdrawal situation. For the state's case to make any sense whatsoever, you must be comfortable with their theory in that Andy Chow is in the store. Andy Chow runs out of that store. Andy Chow runs out of that store after Cyrus. And as he's running out after the person he thinks is shoplifted him, Cyrus still points the fire. Andy still has his hands up. His dad is still watching, and his dad says, no, I'm not going to do anything. And Cyrus shoots and kills his son. The state wants us to believe that that's legal, and that's okay. That storekeeper should let people take stuff out of their store, and if you follow them and you get killed, it's okay. It's not. Now, you know the rest of the story.
Anything in reply to the state?
Yes, Your Honor, of course, the notice is fine. We'll come to you around.
Yes, sir.
Please go, Chairman.
Yes, sir.
Counsel. Mr. Kent spoke to you guys, ladies and gentlemen of the jury, for a moment or two. And he talked about Paul Harvey and the rest of the story. Sounds a lot to me like this was the rest of Mr. Kent's story. Because many of the things that he said were things that he said, but the actual eyewitnesses never said. Reminds me of when I was a kid, a couple of years maybe before Mr. Kent, but a whole lot of years after Mr. McCullough, Mr. Swirl. We used to, as kids, go down to Augusta, Georgia. My grandmother was from a small town called Trenton, South Carolina. It's in Edgefield County. And way before I was born, probably when I was still a twinkle in my parents' eye, she moved down there because there were just better opportunities to work. And so as I'm growing up in the early 70s, early 80s, my folks would drop me and my brother off down there, and we hang out with my grandmother for a week. And back then, when you went to your grandmother's house, you couldn't stay inside and play video games all day because they didn't have them. So we had to go outside. We had to find ways to busy ourselves. We had to do things outside so we didn't break anything inside and get in trouble. So what we end up doing is my brother and I would go outside and we'd start throwing the football around for a little while. We tossed the baseball around for a little while. Then we would start running around her house because my brother was older, so I tried to catch him. So we try to run around and see if I got any faster than he. At some point in time after lunch, we would make our way to this makeshift barber shop that my grandfather had built on the side of the house. And we'd sit down and we'd listen to the old man playing checkers, trying to pick up on some words we probably shouldn't have been hearing. We'd hear him slapping the checkers on the board, saying "king me" and all that kind of stuff. And we'd be learning some old man stories as kids. It was fun. We'd sneak into a little side of the barber shop and try to get his red man chew. And the joke was we'd try to put a little piece in our mouth and try to hold it in there as long as you could before it burned a hole in your mouth. But we try to hold it in there and try to see who could hold it the longest before you started gagging. This mischievous stuff that kids do. That's what we did. But at the end of the day, every evening, my brother and I would end up on the front porch. And my grandmother had a set of rocking chairs out there. And we would sit in those rocking chairs and start playing what I call rocking chair games. The first game, we'd sit down and then we'd try to see who could rock the fastest. I'm sure some of y'all have done this. Then we try to see who could rock the fastest and the farthest with your legs in the air. It's good ab work if you ever need to do it. We're trying to go back and forth and see how fast you could go with your legs in the air. And inevitably, the last thing that my brother Chris and I would do, we'd sit down and we'd rock the chair as far back as you could go without it falling over. And we'd do that. And we did that over and over and over. One evening, my grandmother came outside and she saw us standing those rocking chairs up on edge. And we knew we were in trouble. Again, this is the 70s, early 80s. This is the day of knockouts, not timeouts. We knew we were about to get in trouble. But my grandmother said something to me that stuck with me and it still rings in my head today. She said, the funny thing about rocking chairs is that they'll keep you busy, but in the end, they don't get you anywhere. The funny thing about rocking chairs is that they keep you busy, but in the end, they don't get you anywhere. Ladies and gentlemen of the jury, Mr. Kent, Mr. Swirler, Mr. McCullough, and that team over there has kept you busy with all of this stuff. But at the end of the day, the question still remains, what is the value of a human life? They have kept you busy with these insinuations that Cyrus was some young thug, some thug in training, running around Columbia, their words, with a loaded pistol, an empty backpack, and no money. Their words. They have kept you busy with this insinuation that this case has to be about and is only about, and is mostly about, a 14-year-old carrying a gun. We keep talking about why do 14-year-olds have guns? Why do children carry guns? And folks, let's be abundantly clear. Cyrus should not have had a gun. Period. No question. Nobody at the state stable has suggested that he should have. But let's put that aside for a second as we talk about what this case is really about, because he shouldn't have had a gun. No question. Question, are we still having this conversation if Cyrus is 24 years old, if he's 20 years old, if he's 34 years old, 44 years old? Are we having this conversation? Somebody wrongfully accused of stealing, chased out of the store after they tried to de-escalate everything that they could, running, falling down, running out of your chute, tripping, dropping phones, running farther, falling, busting your shin, gun spills out, you're still running. And according to the testimony that you've heard from this chair, grown man, Andy Chow, state championship swimmer, 185 pounds, 200 pounds, about 85 pounds more than Cyrus, was right on top of him when he fell. And Dad was close by, in arm's distance. That's what the testimony was, not this, all this stuff. He was right on top. Question, as you listen to the elements of self-defense, not bringing on the difficulty, who would have had a claim of self-defense in this case? Cyrus? being chased by two men armed with a gun on top of you after you've run 130 yards. Folks, I submit to you, as I'm walking from that tip back here, you get to the end of this courtroom, that's 20 yards, 19 yards. Times 5 plus 30 more yards. That's how far he was chased. So who would have had a self-defense claim? So I'm suggesting to you that they keep insinuating these things, saying these things, because they don't want you to think about it. Again, I mentioned to you this to you multiple times. When you parked your cars, you didn't leave your common sense in the parking lot. Take it with you. Think about these things. Don't let them sway you with all of this mess and all this other stuff that takes us off of what the real issue in this case is. Don't let them do it. The defense kept weaving this narrative, again, that Cyrus is some young thug walking around the streets of Columbia, again, with a loaded pistol, no money, and an empty backpack. I submit to you that, folks, if Cyrus was this thug that they keep telling you that he was, by showing you pictures and trying to get you thinking in that direction, we never would have gotten 130 yards down the road. He would have held court right at 7441 Park Lane Road. Cyrus would have been the judge, the jury, and the presenter of the sentence right there in that spot, if he was the thug that table wants you to believe that he was. But instead, what were his actions? Folks, he ran. He ran like a child. He ran from the adult. Let's think about who acted like the thug, the gangster. The person who chased him down the street, or the person who ran while he had a gun hidden. He ran out of his shoe. How do we know that to be true? Because we see it on camera. Shoe flies up in the air, and he keeps running. Doesn't stop. Turn around. Oh, I dropped my shoe. Let me get that, because I'm going to get in trouble if I go home with one shoe. He didn't do that. How afraid do you have to be to run out of your shoe and not turn around to pick it up? Ponder on that for a minute. He ran further. Phones fell out. They keep coming to you with this mess that, oh, he threw his cell phones out. What sense does that make? Did you leave your common sense in the parking lot, or did you bring it with you? How afraid do you have to be to drop 2 cell phones and keep running? Again, let's be very logical about this for a minute. 2 cell phones. We know how expensive they are. One cell phone belongs to you, and the other belongs to your mother. Do you mean to tell me that you are going to go home that day with one shoe and tell your mother, Mama, I lost my cell phone and yours too, and I didn't turn around to get it? You want that smoke? Do you really want to get what you would get if you lost 2 cell phones from your mother? But you know why he didn't turn around? Because he was scared. Because that man, armed with a .45 caliber pistol, and his son were chasing him for no reason down the road in South Carolina. Chasing him. Didn't turn around. Kept running further. Fell again. Hard. Dropped the backpack. And by the way, since they want to keep saying it was empty, actually had some personal effects in it. There was an address in the backpack. Really? Fell. Dropped the backpack. Didn't stop and say, oh, stop, guys. Let me go get my backpack. Let me go get the phones. Let me go get the shoe. Kept running away from them. Is that a thug? That's a kid who was scared of 2 grown men, running as fast as he could, as far as he could, trying to get home. But they wouldn't allow it. They would not. For some reason, they could not allow it. And then, at some point, as he fell, hit the ground, that gun comes out, that tack light comes out. Now, I'll suggest to you, as Mr. Kent talked, he keeps saying, well, he was picking up the gun and he was pointing the gun, all that kind of stuff. Stop, just stop. Because what we say is not evidence. I told you before, the evidences will come from this witness jury. There were 4 eyewitnesses who were not named Chow. Which one of them ever said they saw Cyrus Carmack Belton point a gun? Which one? Which one? No. 4 of them. 3 different vantage points. Lori Carson, Kennedy Carson, mom and daughter. They told you they watched and they saw a straight line of what happened. Cyrus ran, fell, hit the ground, got up running, and that's when he was shot. Asked multiple times, well, did he turn at them? Did he point at them? Did he do anything? No, we never saw anything in Cyrus's hands. 2 witnesses, mom and daughter, vantage point at the front of the store. Didn't see any of that. Any of that. Devontae Bryant, driving, white Honda, threw on brakes so he wouldn't run over anybody as they ran in front chasing Cyrus. Asked as he rode by, did you see him point anything? Cyrus Carmack Belton point, stop and point. No, he didn't. He didn't have anything in his hands. The book bag fell. He was flat. He fell hard. His hands were on the ground. He got up trying to run, and that's when he was started stumbling again and got shot. Again, trajectory. Here, upwards, to the left, making perfect sense that he's running away. Not pointing, like the defense wants you to believe. Remember the multiple times they tried to see with Dr. Durso, well, was he doing this and was he snaking and popping and locking? No, none of that was ever said. He was running, and when they tried to do that, he said, no, it's more consistent with the shooter being directly behind him. Folks, if he was turned in the direction that they want to believe, his spine would have been severed by that bullet. Common sense. You didn't leave your common sense in the parking lot when you parked today. You brought it with you. That again is why we went through that process. Some of you may think it was painstaking last week to sit you as jurors, because we wanted you to take the facts of this case, not Paul Harvey, not Steve Harvey, not some other Harvey, but the facts of this case that came from this witness chair. Not some stuff that's speculated or what we can kind of come up here and start trying to come up with about moonwalking backwards and all this kind of stuff. But none of that. The evidence that came from this chair. Did you hear that? Another witness, Jasmine Broadwater. Another vantage point. They're running directly to her. Did she say she ever saw a gun in Cyrus's hands? No. Did she ever say she saw Cyrus point? No. Nobody with the last name that's not Chow says that ever happened. And interestingly enough, you saw in the video, after the shooting took place, who were walking around? Richard. The officer had to tell him multiple times, stand still, don't touch evidence. I'm gonna charge you with obstruction, you keep messing around there. Moved the gun, by the way. He and his family went to the store, came back, had plenty of time to talk about what they were gonna say. Plenty. But at the end of the day, when Andy sat up here, there was nobody to protect him from cross-examination. Nobody to protect him. There was conversation about a barrel. Andy says, I saw a silver barrel. Folks, I submit to you, there is a gun like one here. This is not the condition of the gun. You'll see it on that video. The condition of the gun was this. That's a black barrel, right? Ladies and gentlemen of the jury, we talk about credibility and believability. Well, we'll get to that in a minute. One other thing that the esteemed table said is that Cyrus Carmack Belton, again, wandering the streets with a loaded pistol, empty book bag, no money. Now, I'll take this on myself because at the end of the day, I'm the boss. And I'm the person who at the end of the day gets the opportunity to say, hey, we need to bring this witness to that witness. So y'all blame me for this one. This is my fault. I will say this, it's my fault. maybe we should have brought in another expert. Maybe a 10-year-old or a 12-year-old or a 13-year-old who could talk to us about the intricacies of cell phones. My gosh, maybe they could tell you that if you hit the right click button on an app. Yes, sure. So maybe we should have had an expert to talk about apps on phones and the fact that in 2026, even back in 2023, you did not have to have cash in order to buy stuff. You can pay on the phone. Maybe that should be an expert that we call next time, since they made such a big stink about those things. Folks, Andy was an interesting person on the stand. And I'm sure that it's tough to have to sit in that situation and recall what was said and what wasn't said and what you thought about in those moments. But it was interesting to me that under direct examination, that testimony flowed. It was quick. Everything that he said was perfect, just came out like water. Then on cross-examination, and y'all get a chance to watch from your vantage point, that's the word of the week, vantage point. Every time he was asked a question on the cross-examination that wasn't pleasant, that actually required some type of thought process that may not go exactly how he rehearsed his testimony, eyes. To the point to where he said, well, my counsel said I couldn't. You don't want to know what your counsel told you. But every time a hard question came, his eyes went from here to there. Folks, I was taught a long time ago, when you lie, you got to remember what you see, right? And if you lie about the small things, then you can't be trusted with the big things, the truth about the big things. So think about that for a minute, because when we talked to Andy, there was a back and forth about simple stuff, like through versus dropped, right? Like pulled versus pointed, which again, no witnesses not named Chow ever said the word pointed. Like chase versus follow. Why are we having conversations about chase versus follow when you saw how fast they were going after? Folks, I may not be the sharpest tool in the shed, but to me, running after requires you to be going after something for a purpose. Example, there's a kid, ice cream truck passes by the house, ding, 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 ding. You miss it. You go out the house and you run after the ice cream truck. Why? Because you want to catch it so you can get some ice cream. Simple. Or sitting, you wake up a little bit late for school and you hear the bus go by. You're missing the bus. You run after the bus. Why? So you can catch the bus and get on and get to school. Or maybe more recently, flying from Columbia to North Dakota. And there's a flight that first leg takes you to Charlotte, second leg takes you to Minneapolis. You get to Concourse A, Your flight takes off in 28 minutes. What you gonna do? You're gonna run to Concourse C to catch the flight. Why? Because you don't want it to leak. You run with the purpose to catch. Folks, I ran after my wife for 2 years and I caught her. But do you think when I caught her, I said, hey, I want to give you directions about how to get to that dude so he can tell somebody else about something. Come on, folks. When you parked your car, you didn't leave your common sense. They ran to catch. At the end of the day, what happened here is simple, and they don't want to admit it because it hurts. They ran after Cyrus emotionally. They were irritated. They were mad for whatever reason. They ran after him. They caught him. They caught up to him because he fell multiple times. They wanted to shake him down and get that bottle of water and then figure out what to do with the police later. That's why they ran. That's the simple truth. That's the simple truth. That gun spilled out. And then that man made a rash decision. He overreacted. Andy saw the gun. He said gun, and he shot him. There wasn't all this time to back up. No witnesses even say that he even backed up. They said they were advancing the entire time. Folks, don't let the defense rewrite the facts because the things they talked about didn't happen that way. They didn't happen that way. For over an hour, Andy sat on that stand and he said a lot of things. He said a lot of things. But did you ever hear the 2 words? I'm sorry. I'm sorry that I wrongfully accused this kid of stealing and chased him down the road. You know why? You didn't hear that? Because he's not. This is about product over people. This is about inventory. This is not about a person's life. Mr. Kent spoke about withdrawal. And he keeps trying to suggest that Andy Chow withdrew by doing this and coming backwards all this way and saying, hey, stop, hey, Dad, you gotta go. Nobody testifies that happened. He doesn't have the last name of Chow. 4 people who don't know one another, who had to be subpoenaed to come to this court, spoke to you, and they never said that it happened because it didn't happen. He did not withdraw. They kept going forward. They kept going forward. And ultimately, this gun was never pointed. But folks, I suggest to you, even if it was pointed, he was running in the opposite direction. Opposite direction. That's what the evidence shows by the way he was shot. It was in the opposite direction, trying to get away. I'll say this. It's offensive to hear the defense keep trying to characterize Cyrus as this young thug. But it's equally offensive to then try to characterize Andy Chow as Mr. Rogers. Excuse me, Rick Chow, the defendant in this case, is Mr. Rogers. You know, the man who chased a kid down, shot him in the back. And then they want to say, well, he was trying to help, clean vomit out of his mouth to resuscitate him. Folks, that's offensive. Because the last face this scared child saw as he ran away was that man peering over him. Peering over him. And none of this happens if they stay their behinds in the store and use that intricate camera system that picked up on every angle. Could see everything from what he wore, the type of shoes that he wore, the direction he went, everything. A couple seconds is all it would have taken, just like it did in the store, to say, hey, you know what, we were wrong. But they didn't do that because they were overcome with something. Maybe it was meanness. Maybe it was malice. Maybe there's some nefarious intent in their heart, a reason for them to chase him and shoot him in the back and end his life. But again, never the 2 words that matter most. And I'm sorry, I made a mistake. However, none of them, because they're not. I talked to you about a poem by Omar Khayyam called The Rubra. And I told you that I would link it all together. The moving finger writes, and having writ moves on, nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wipe out a word. Folks, that's a poem about time and how you can't erase what's been done. You can't go back and change what's been done. With all your piety, no matter how many degrees you got, how many doctorates you got, when you do something, it's there, it's done. And you can't reverse time. You may try, you may get up here and get on the stand and try to think your way through it and reason your way through it. But at the end of the day, what they did was murder. So in a more literal sense, eventually we're going to be asking that your moving hands come back and write these words. Because Rick Chow is guilty of the murder of 14-year-old Cyrus Carmack Belton. Now, folks, you're going to have a chance to deliberate in a moment. And as you deliberate, you will apply the facts, in this case, to the law that the judge is going to give you in a couple of moments. And as you do that, I'm asking, Dale Scott is asking, Stephanie Chandler and Weston Lee, for all of us are asking that you return a verdict of guilty in this case. I'm just looking to make sure that I covered everything that Mr. Kent covered. I ask you to think one last thing, and I'm out of your face. We all know there are 50 states in the United States of America. But I think I've learned sitting in this trial that there are actually 51. There's the state of denial. The state of denial is where that man lives because he's denying that what he did was wrong. He's denying that he chased and killed that young child, Cyrus Carmack Belton, who never pointed a gun at him. The witnesses tell you so. Not his son, who's got every motive, every reason to twist it around in order to protect his father. Denial that you, the jury, believe or will believe that what he did was wrong. Denial that at the end of the day, he believed that a human life was not more than that. Folks, it's for these reasons that the state of South Carolina is asking you to return a verdict of guilty, because Chai Key Rick Chow is guilty of murdering Cyrus Carmack Belton. Thank you for your time.
Thanks, Mr.
Take care.
Madam Forelady, ladies and gentlemen of the jury, you've heard the evidence and the arguments of both parties. I'm now going to explain the law to apply in this case. Well, maybe I'll do that in a moment.
Quiet, building sector.
Now, the charges that I'm going to read to you will not be sent back to the jury room, so it's important that you listen carefully to the instructions. If you have any questions during your deliberation, I can bring you back out, and explain the law to you again if you have specific questions about the law. Now, you and I have specific duties to perform, like we discussed from the outset. As a trial judge, it is my responsibility to preside over the trial. It's your responsibility to consider the testimony which has been presented from the witness stand and the exhibits introduced. I have the duty to charge the law applicable in this case. As presiding judge, I am the sole judge of the law, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I tell you, the law is you must abandon your idea because you are sworn to accept the law and apply the law exactly as I stated to you. Your duty is to determine the facts. In every case, the jury is the sole and exclusive judge of the facts. A trial judge cannot suggest, state, comment on, or make any statement to a trial jury about the facts in the case. Since you are the sole judge of the facts, you are not to infer from what I have said during the progress of this trial and ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in the case. The law does not allow me to have an opinion about the facts. This is a matter solely for you to determine. As jurors, it is your duty to determine the effect, value, and weight of the evidence presented during the trial. The indictment charges the defendant with murder. The fact that the defendant was arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt at all. This indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court and gives this court jurisdiction. The defendant has pled not guilty to the indictment, and that plea puts the burden on the state to prove the defendant guilty beyond reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is a guiding rule of law that the defendant in a criminal trial, no matter how serious the charge, is always presumed innocent of the crime for which the indictment was issued unless guilt is proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on the evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a real and substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. The state has the burden of establishing every fact necessary to prove the defendant guilty beyond a reasonable doubt. The law presumes every person charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. The defendant is not required to prove his innocence. Some of you may have served as jurors in civil cases where you were told it's only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. Other civil cases use the clear and convincing standard. In those cases, it's necessary to prove that a fact is highly probable. But this is a criminal case, and the state's proof must be more powerful than those burdens of proof. In criminal cases, the state's proof must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. The defendant is not required to prove his innocence. If, on the other hand, you think there's a real possibility that the defendant is not guilty, you must give the defendant the benefit of every reasonable doubt and find him not guilty. Necessarily, during your deliberations, you must determine the credibility of witnesses who have testified. Credibility simply means believability. It is your duty as juror to analyze and evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in the case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of the witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motives in the case. You may also consider the appearance and manner of the witness while on the witness stand. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use the evidence of the earlier contradictory statements to determine the truth of those statements. It's up to you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the way you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances existing at that time. There's no way to prove intent to a mathematical certainty. There's no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances showed to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state of conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances existing at that time. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that are considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of the fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof as failure. The state has a burden of proving the defendant guilty beyond reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. As I mentioned to you during the trial, the rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witness. A witness who, by education and experience, has become an expert in some art, science, profession, or calling, may state an opinion as to relevant and material matters in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradicted. I instruct and emphasize to you that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact that the defendant did not testify. The fact that the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt as to the charge against the defendant. The defendant is charged with one count of murder. The state must prove beyond reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exist for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms express and infer do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when a person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or of any other act of preparation going to show that the deed was within the defendant's mind would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would simply be an evidentiary fact to be considered by you along with the other evidence in the case. You may give it the weight you decide it should receive. The defendant has asserted defense of others as a defense to his prosecution. Under the law of self-defense, the defendant may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have had the right of self-defense. Defense of others is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving defense of others by proof beyond a reasonable doubt, and the burden is carried by disproving any one of the four elements by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all of the evidence, including the evidence in defense of others, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence in defense of others, then you must find the defendant guilty. The following elements are required to establish self-defense, and in this case, defense of others. First, to show that the person being defended had the right to self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing on the difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. One's right to self-defense or defense of others is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. Second, the defense of another person is excusable if the defendant had reasonable grounds to believe and in good faith did believe that the person being defended was in imminent danger of death or serious bodily harm from the victim. In deciding whether the person defended actually was or that the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical conditions and characteristics of the parties. The defendant does not have to show that the person defended was actually in danger. It is enough if the defendant believed the person was in imminent danger. The defendant has the right to act on appearances, even though the defendant's beliefs may have been mistaken. The third element of self-defense requires the defendant to show that under the circumstances as they appeared to the defendant believed the person defended was in danger, and that a reasonably prudent person of ordinary firmness and courage would have had the same beliefs under the same circumstances. It is for you, the jury, to decide whether the defendant's fear of immediate danger or of death or serious bodily injury to the person defended was reasonable and would have been felt by an ordinary person in the same situation. The defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense of others, to prevent the victim from inflicting harm on the person defended. The final element necessary in order to be entitled to defend another requires that the person defended have had no other probable way to avoid the danger of death or serious bodily injury than to act as the person defended did in this particular instance. Where the person being defended had no duty to retreat, the defendant likewise would have no duty to retreat. The defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury would increase. When considering defense of others, the relative sizes, ages, and weights of the parties may be considered in deciding the apparent or actual need for force in defense of others and the amount of force needed. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in defense of others, the defendant has the right to use the force needed to avoid death or serious bodily harm to the person defended. The force used in defense of others does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appears to be necessary for complete protection of the person defended, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm to the person defended. Where a person inflicts an injury or death on another person, you must be convinced beyond reasonable doubt that the defendant's actions were the proximate cause of the victim's injuries or death. The proximate cause is the direct cause. It is that immediate cause. It is the efficient cause. It is that cause without which the injury to the victim would not have resulted. There must be a chain of causation from the defendant's actions until the time of the victim's injury or death. Proximate cause does not necessarily mean that it occurred immediately prior to the injury or death. There may be more than one proximate cause. The acts of two or more persons may combine together to be a proximate cause of the injury or death of a person. The defendant's act may be regarded as a proximate cause if it is a contributing cause of the injury or death of the victim. The fact that other causes also contribute to the injury or death of the victim does not relieve the defendant from responsibility. The defendant's act need not be the sole cause of the injury or death, but must be a proximate cause contributing to the injury or death of the victim. Negligence on the part of someone else would not relieve the defendant from criminal responsibility if the actions of the defendant were the proximate cause of the victim's injury or death. Ladies and gentlemen, I declared the law to you through these instructions to help guide you to a verdict. Whether some of these instructions apply depends on what you find to be the facts. The fact that I have instructed you on various subjects in this case should not be taken as indicating an opinion of this court as to what you should find to be the facts or as to what your verdict should be. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. The verdict must be unanimous. All 12 of you must agree on the verdict. The verdict cannot be based on sympathy, passion, prejudice, emotion, or any other consideration not in evidence in the case. Disagreements may arise during deliberations and your debates may become spirited. I urge you to be courteous and to one another and respectful of your fellow jurors' perspective as you work toward a verdict. Remember, at all times, you are not partisans favoring one party over another. You are the judges of the facts. Your sole interest is determining whether the state has proved the defendant's guilt to the charges beyond a reasonable doubt from the evidence presented to you in this case. Again, ladies and gentlemen, your verdict must be unanimous. Madam Forelady, when the jury agrees on the verdict, you will fill out the verdict form, which I have here. It is very self-explanatory. It will go back with the evidence. After you reach the verdict, Madam Forelady will fill out the verdict form and sign. Then knock on the jury room door and inform the bailiff you have reached the verdict. At that time, we'll receive you back in the courtroom. We'll ask you to return to the jury room and not begin deliberations until you're told by the clerk or the bailiff to do so. There are a few more matters of law that I need to discuss with the lawyer before you begin your deliberation. All right, so I'm going to ask you to help back. I believe your lunch is already here. So y'all can get started with that. We'll be with you very shortly. I'm going to ask the alternates to please stay with us. Exception to the charge and state.
None, Your Honor.
Any exception from the defendant?
Your Honor.
Judge, can you indulge us one moment? I need to find something. All right. Give me a minute.
While y'all are working on that, our alternates, you are now excused. You do have lunch back there. But thank you for being here. Again, like I said from the outset, we can't do our job without folks being willing to show up. It's very, as you can see, it's a very important job. So again, thank you for being here. But you are excused. I always tell jurors you certainly have the right to discuss your observations with the lawyer. Sometimes the lawyers would like to see input, but you do not have to. If anyone contacts you in any way about this case, and you feel
Hi, everybody. So that is the conclusion of the closing arguments. I just wanted to. So manslaughter is not even on the table. They didn't ask for an instruction on a lesser included offense. So this is an all or nothing thing. And I think that doesn't bode well for Mr. Chow. I was going for a manslaughter, but I think he's going to get convicted. I don't believe that this was self-defense. I don't believe it. I just don't. I'm not buying it. So What did y'all? I know what Julie thinks of the defense tactic, but that was the strangest closing argument I've ever seen. He started out by sitting on the witness stand, and then just yelling at the jury. To me, it's very off-putting when somebody yells. I don't want to be yelled at. I don't. It just gives me the willies. It turns me off. And I did not like that tactic. I thought he was making good arguments, valid arguments, but I was so put off by the loudness of it that it just, yeah. Poor Rick. He's going to prison. He's already served 3 years, which if he had a manslaughter conviction could have gotten him time served, because the penalty for that is anywhere from 2 years to 30 years in South Carolina, but that's not even on the table. So I need to change my poll, take that out. Did anybody fill that out? I did put a poll up. I don't know what happened to the StreamYard one. Who knows? But there is a poll now on the community page. Just looking to see if y'all found it. But in any case, there's only one person out there watching me right now anyway. Oh, goodness. Okay, well, so anyway, I'm going to leave this running. Or actually, you know what? I'm going to shut this down. If there happens to be a verdict, and I don't think this is going to be quick. I see a hung jury, maybe. I just don't know that you're going to get 12 people to. Sue's here. Hi, Sue. It's just you and I. And thank you. If you're watching my feed, thank you so much. I know there's other feeds out there that have the trial, but this is one where you can craft and watch it at the same time, and we all have something in common, and we all know each other. So thank you for watching on the feed. So I'm going to shut down the feed because I want to grab some clips out of it. I want it to be available to rewatch. It is already, but I will go back live if there is a verdict. I do have some errands to run, but I think I have plenty of time for that before there's a verdict because, it is 12:30 in South Carolina. So I suspect somebody's going to order these people some lunch and they're going to eat their lunch and then they're going to start deliberating. They already have a 4-person that was assigned by the judge. So there's Julie, fully caffeinated, as you can see. Oh my goodness, that's ma'am. I didn't finish my second cup of coffee. It's probably cold, which I don't mind. I don't mind cold coffee at all. I've been sitting here. Let me show you what I've been working on during this trial. I'm just working on this little picture here, and I've almost got it all filled in. I'm not doing sections. I'm just doing one at a time. Not one at a time, but one color at a time. And then I think I have an old picture in a frame that I don't really like anymore. And I think I might put this one in and maybe find a place for it in my new home. Yes, it's small. It'll fit. Anyway. All right. I will be back. If there is a verdict, please look for that thumbnail and I will. And Sue, feel free to text me if you see them come in before I do. I'll see y'all later. Have a great day, everybody. Take care.